Welcome to this presentation from our textbook, Chapter 2, and the name of the chapter is Government Agencies that Impact the Hospitality Industry. We'll see in this chapter that we'll cover just a lot of agencies and their role in enforcing laws and creating regulations and how that might impact the hospitality industry. We're not going to do a very deep dive into many of the agencies, but I'm going to kind of hit on a few high points, things that might be of special interest. As always, when you see the lecture, please don't assume that all you need to know is what's covered in the lecture. You're still responsible for all the stuff in the textbook as well. So let's go ahead and make some progress. We're going to talk about federal agencies, and we're going to talk about state and local agencies. And we're going to talk about what to do when agencies between these various branches of government conflict with each other, and how to respond to some type of investigation or inquiry or complaint from a governmental agency. And finally, we'll talk about how to stay current with all of these regulations. We talked in Chapter 1 about the fact that there's going to be changes as technology and as cultural changes happen in our society, and both of those are inevitable. There's going to be some changes to the regulations that come down the pike, and how the steps that we need to take as hospitality managers will evolve. So everything that we cover today is a snapshot in time. We'll find probably more agencies, different agencies doing different tasks in 5 or 10 or 20 years from now. So again, we're going to talk about federal agencies, state agencies, local agencies. We're going to talk about managing conflicting regulations, how to respond to those types of inquiries, and how to keep abreast of changes. We're going to start with the IRS, everyone's favorite agency, right? And we're going to talk about, because this is probably one of the more dense areas that we need to look at. I would say most hospitality managers are not usually in the front lines of this. Most of the time, if it's a larger organization, there's going to be some kind of tax or accounting department that is primarily responsible for the IRS communications. If it's a smaller entity, you might have a CPA that you either have in-house or perhaps that you've hired. But even if you're not directly involved in the day-to-day number crunching and report writing that needs to happen with respect to the IRS, it's important for you to know what needs to happen even if you aren't the person doing it. And you might find in some organizations that you are the person. A helpful document to use as a reference will be Publication 15 Circular E, which is Employer's Tax Guide. Let me show you, well, actually I'll show you in a second how to find that. That's an overview of all of the different responsibilities that the employer has with respect to communication with the IRS. Obviously, the employer has to pay income taxes from the wage payments that the business makes, and this is done on a quarterly basis. And so there's a particular form that employer needs to file. The employer can't keep that money and the taxes withheld from that money for a whole year, has to pay that out every quarter. Then there will need to be every year an income and tax statement that is with respect to the Social Security Administration. As you know, the employer collects FICA taxes. It contributes some of the FICA money, and also the employee contributes some of the money. And so this needs to be reported to the Social Security Administration on an annual basis. As we said before, there needs to be the withholding of income tax, and those need to be deposited with the IRS. There's special responsibilities in the hospitality industry because many of the employees in this industry work on a tip basis, and there are very specific rules about how tips need to be collected and not so much collected because of course the employee keeps the tips, but that data needs to be collected and reported to the IRS, and how we handle the income tax obligations that attach to that. Particularly again in the restaurant industry, it's not unusual for employees to receive free meals or reduced price meals as one of the fringe benefits to them working at a particular place of employment. Those count as income. The IRS wants taxes paid on that money, and so there is a responsibility to keep track of that. Sometimes hospitality industry businesses will not necessarily hire somebody to do a particular task, but may use independent contractors. If you're using independent contractors, it's pretty common to issue a 1099 or a 1096 depending upon the circumstance. Definitely that income has to be revealed to the government so that the government can make sure that that independent contractor is paying appropriate taxes on that. And obviously once a year, typically in January, the employee, all employees, current and employees who are no longer employed but worked in the previous year, are entitled and need to receive a W-2. And that information is necessary to ensure that the employee reports the correct numbers to the government, and the government can confirm the accuracy of that information. So as you can see, there's lots of different tasks that employers have to do with respect to the IRS, and it's important that these be followed to the letter, both in terms of what needs to be filed, the accuracy of the information, and the time period that it needs to be filed in. So now I'm going to show you where to find this Publication 15 Circular E document. So I'm going to bring this down. So we go to the irs.gov website. That's a pretty common naming convention for federal government agencies. You have an abbreviation of the agency, then a period, and GOV. Then we're going to go to Forms and Publications, and we're going to type in Publication 15 Circular E. That's the name that we are looking for. Here we have Publication 15 Circular E. And it should be, I think, the stop on. Ah, yes, here we go. So you can see it's not a short document. It's not something that you're going to read once and have it done. But it's a good resource to have. And again, if this falls into your area of responsibility, having some familiarity with it can be a very important compliance task for you to be sure it happens. By the way, the instructions about how to access this information isn't exactly correct. The way that I found that information is a more reliable way to get it. We're all familiar with the fact that the IRS can audit our records, and certainly as individuals, our situation can be audited, our income tax returns can be audited, but certainly businesses are routinely audited. In fact, many businesses are automatically audited every year, so it's definitely something that you will likely encounter as you work in industry. In fact, it's not at all unusual for the IRS to have a set offices within a large corporation where they're always there because they're always auditing the records of that large organization. Another important governmental agency is OSHA, which stands for the Occupational Safe and Health Administration. That's also by the way, the name of the statute, OSHA, which stands for the Occupational Safety and Health Act. The employer has a lot of responsibilities in this area, and they are definitely relevant in the hospitality industry. The first and foremost, and this applies to all employers, is the employer is required to provide a safe work environment for his or her employees. All employees should be in a situation in which they will be safe. And this is called the General Duty Clause in the statute. And it has been interpreted in a variety of ways over the time, the time that it has been in effect. And because it is fairly vague and broad, it lends itself to evolution. Some of the topics that have come up under this general duty clause has been repetitive work injuries such as carpal tunnel syndrome, topics like sick building syndrome, where people have become ill because perhaps the building isn't as ventilated as some people think it ought to be. So there's lots of differing issues that may not be obvious. We're not simply talking about conveyor belts that people's hands get caught in or things along those lines. These can even arise in a white-collar type of environment. And definitely the hospitality industry opens itself up to these types of issues. For example, in a hotel, you're going to have industrial size laundry facilities. You're going to have chemicals that are being used to clean hotel rooms. Very possibly you'll have bars and restaurants where food is being cooked. Knives are being handled. There definitely are risks associated with that. In addition to maintaining a safe work environment, the employer is also required to train its workers to be safe. And obviously that's part and parcel of having a safe work environment, because there's very few work environments that are 100% safe, even when the employees don't know anything about how to be safe. Part of the task of being safe is recognizing the hazards in the work environment, and definitely that is part of the training. We talked in Chapter 1 about the idea of STEM, and you may recall that the T in STEM stands for train. And we can see that this is coming up again here with the Osha concerns. Even when we work very hard to maintain a safe working environment, things happen. People are going to get injured. Sometimes it's going to be because it's that 1 in a million thing that happens. Sometimes it's going to be somebody was goofing off or doing something they weren't supposed to, or some type of machine didn't work as it was supposed to. But whatever caused the problem, serious workplace accidents have to be reported to OSHA. Deaths have to be reported within a very short period of time. Other types of serious injuries have to be reported quickly as well. And so you have to be aware of when those reporting requirements are, how that information is reported. And you need to be aware that that is a place that you need to go. In addition, all workplaces need to have an OSHA 200 log where all workplace injuries are listed. All employers are required to have OSHA notices posted in the work environment. These are posters that go up typically in 2 areas. One is an area where applicants can see all of the various governmental postings, and the other is an area where the current employees have access to information. This might be in the locker area for the employees, or the place that employees clock in or clock out, or perhaps it's the place where they take their breaks or change clothes or things along those lines. Sometimes those 2 places, the place for the applicant, the place for employee, are separate. Sometimes they're the same place. But wherever the place is, you need to make sure that you have the OSHA notices posted so that workers have access to information about their legal rights in this respect. Failure to post these notices is actually a violation of OSHA. And so even if you're doing nothing else wrong, if you're not posting the notices, you are in violation of the Act. Another thing that's important to do is to post, not just to post, but to distribute, to provide access to the Msds for a particular product that a particular worker might use. For example, in Chapter 1 we talked about Sally. Sally's responsibility was to clean toilets in the various hotel rooms in the hotel in which she worked, and she used a variety of products, and some of those products could not be mixed together safely. And the way that Sally would know about that would be this information, this Msds, that she would receive and have access to, and she would have the ability to review it. So when she's looking at Ajax, or she's looking at Comet, or she's looking at bleach, she can look at the ingredients and read what can be combined with it and what can't, to make sure that she doesn't cause herself harm or cause other individuals harm. You do need to know about this term. Again, MSDS stands for Material Safety Data Sheet. It's something that the manufacturer provides, and it lists the potential risks associated with using this product and how to handle the product. And there's MSDSs for virtually everything from liquid paper to toner fluid to Sharpies, to really pretty much anything that is used either in a white collar or an industrial environment. And certainly those documents would be important things for a hospitality manager to provide to the workers that are affected by that. Okay, so we've talked about OSHA and what the rules require, but let's talk about how the administration actually does its job. There's several different ways that an OSHA investigator can get involved in a case, and we'll have more discussion about employment law regulation in subsequent chapters, but let's just talk a little bit about OSHA right here. OSHA becomes aware of issues in a few different respects. Sometimes an employee, perhaps a current employee, perhaps a former employee, perhaps a potential employee, contacts OSHA either anonymously or on the record and raises a concern. Sometimes the concern is valid, sometimes the concern is not. That type of complaint can often result in an OSHA investigation. Another reason that OSHA might investigate would be when the employer does one of those mandatory reports. Maybe there was a serious workplace incident where somebody was hurt, and that can easily prompt an OSHA investigation. But there's a third category, and that is just kind of a random investigation. Sometimes OSHA might just visit you just because, or they might be focusing upon a particular industry or a particular part of town or a particular problem, and that might motivate them to visit. They don't have to call you in advance. You just kind of going through your everyday business day, and you get a call or you get a buzz. You suddenly see the OSHA inspector there with his badge. So what does OSHA do? Well, OSHA has the responsibility to investigate worker safety issues. And the people who typically do those investigations are called compliance officers. When a compliance officer arrives, many times it's a fairly stressful situation for the hospitality manager. OSHA's not there to give you good news. Let's face it, the best outcome can be after a difficult inspection, they say there aren't any big problems. But it can also be much less happy as a result. You're not going to get an award for the safest office ever or something along those lines. But whatever happens, you want to be present for it. You want to see what the compliance officer sees. You want to make sure that the compliance officer understands what he or she is seeing. This is especially important if you're in an industry that's a little bit different than what the compliance officer might ordinarily see. Now, probably OSHA inspectors routinely see hotels and restaurants and bars. That's not a super unusual industry, but it's still important to make sure that that inspector knows how to process, how to understand the various things that he is seeing. You'll also want to request the report because the inspector will reduce his or her notes and review into a document, which is the inspection report. OSHA fines can be very, very high, and they can be pretty difficult to challenge. There are ways of challenging them. The best path to think about when you're looking in issues like OSHA is to avoid having a problem at the beginning. If you can avoid that, that's the best of all possible worlds. And the way that you avoid that is by, making your workplace as safe as you can. Obviously, there's no guarantees, but that's a good path to follow. So I guess the point I'm trying to make here is don't assume that, oh, well, this isn't a big deal. It can be a very, very big deal for an employer having an OSHA fine. Let's talk about the EEOC, the Equal Employment Opportunity Commission. This governmental agency, it's a federal governmental agency just like OSHA. It is an agency that has less teeth, has less ability to directly negatively impact an employer. In that sense, it's a little bit less of an intimidating agency. I say that, though, with a bit of a caveat, because even though the agency itself doesn't have a lot of tools in its arsenal to necessarily negatively impact an employer directly, the types of claims that it investigates are actually usually more financially damaging to employers than the OSHA complaint. So it's definitely an area that is fraught with some major, major concerns. And we'll be talking about this area of the law extensively in Chapter 7 and 8. So what does the EEOC do? Well, it investigates employment discrimination and harassment claims by current employees, potential employees, past employees. And so what are the categories of employment discrimination that are protected under federal law? Here's a list. The textbook doesn't do the best job describing these, I'll be honest with you. So please refer to this slide, slide 9, more so than what the textbook says. One category is sex discrimination. And when we talk about sex, we're talking about gender. We're not talking about sexual behavior. We're talking about male or female. Within that category of sex is included the idea of pregnancy. Obviously, only women can be pregnant. So just to discriminate against someone because she is pregnant is considered a type of sex discrimination. Under federal law currently, sexual orientation is not a protected category, and neither is transgenderism. I use the word probably here because there have been some courts in the United States who have, through a variety of legal theories, concluded that sexual orientation and/or transgenderism are categories of sex discrimination. And so it's always possible that the U.S. Supreme Court will eventually reach that conclusion. But it hasn't to date, and I would say it's less likely than not to happen. We happen to be in the Fifth Circuit, which is the circuit court that covers the states of Texas, Mississippi, and Louisiana. For the time being, the Fifth Circuit typically is a rather conservative court, and it is probably less likely than other courts to expand the term sex in the Civil Rights Act of 1964 to include sexual orientation or transgender issues. So for the time being, we probably don't have to worry about a court in this area interpreting sex discrimination to include these two categories. Having said that, that does not mean that an individual employer might have a policy, even though it's not legally required, of saying, hey, it is our corporate culture to include sexual orientation as a category that we want to protect our employees from discrimination based upon that. And again, they could take a similar position with respect to transgender issues. So just because it's not a legally protected category doesn't mean that a company can't extend more protections to its workers. You may be thinking, well, you're talking about federal law, Professor Groover, but what about Texas state law? Well, Texas state law also has protections in this area. But in this case, with respect to all of these categories, Texas state law mirrors the federal law. It doesn't give more or fewer protections. So right now, Texas state law covers sex discrimination and pregnancy discrimination, but it doesn't cover sexual orientation or transgender issues. That's the rule in Texas, but if you go to other states, for example, the state of California or Wisconsin or New York State, you very likely will find, or in those states you definitely will find, that sexual orientation and transgender issues are covered under those state laws. There's even some local laws in certain jurisdictions, including a few in Texas, that do expand the categories to include sexual orientation and possibly transgender issues. So you can't just assume that the way the law is today is necessarily how it's going to be in the future, or the way the law is in Frisco, Texas is necessarily the way the law will be in a different state. In addition to protection from sex discrimination, we also have race and color discrimination. You may think, well, what's the distinction between race and color? Many people conflate the two, and certainly there's some connection between most people's racial identity and the skin tone that they have. But it's not a perfect correlation. For example, I might be African American but have a light skin tone, and my light skin tone might be lighter than somebody who is Caucasian or somebody who is of Asian ancestry. And even though I identify as being a member of a race that, most people would assume is a darker skin tone, doesn't necessarily mean that for each person of that race, that skin tone is darker than a person of another race. So race and color are not necessarily the same thing. Another way that color comes up can be when two people of the same race, but people who have differing levels of skin color might have some challenges in the relationship. For example, imagine that you had a light-skinned African American supervisor and a dark-skinned African American subordinate. Let's say that the darker-skinned African American subordinate is terminated by the lighter-skinned supervisor. The subordinate feels that he or she was discriminated against based upon color. He or she isn't saying it was racial discrimination because he or she recognizes that the supervisor was of the same race that the subordinate was. But the supervisor could discriminate based upon skin color even if that person is not discriminating based upon race. Most of the time when a person complains of race discrimination, they're also going to say color discrimination. And most of the time when someone complains about color discrimination, they're also going to complain about race discrimination. Then we have age discrimination. Under federal law and Texas state law, this begins to be a claim once a person has had his or her 40th birthday. We don't have anything in Texas or in federal law for reverse age discrimination. So when I'm 39 or younger, I don't have any protections under the Age Discrimination and Employment Act. But that's not the way sex discrimination and race and color discrimination works. Sex discrimination isn't protection just for women, and race discrimination isn't protection just for people who are non-Caucasians. Caucasian people can allege race discrimination. Men can allege sex discrimination. So we do have reverse sex discrimination and reverse race discrimination. But we don't have, at least not in Texas or under the federal law, reverse age discrimination. There are some jurisdictions like Florida, for example, that do have reverse age discrimination. Then we have national origin. We talked about this a little bit in Chapter 1, but let's just do a little bit of a refresher. National origin can really refer to two categories of people. One is a person who is actually born in a different part of the world, someplace other than the United States. Perhaps I was born in France. And I eventually moved to the United States. Well, my national origin would be French. If I were discriminated against because of my national origin, being French, that would be a violation of the protections afforded to me under the Civil Rights Act of 1964. But another way that I can be subject to national origin discrimination would be if, even though I was born in the United States, my ancestors came from a different part of the world. Most of us do have ancestors that have come from one or more parts of the world, unless, of course, we are Native Americans. For example, we might find that we have some ancestors from Africa, some ancestors from Europe, some ancestors from Native America, maybe some ancestors from an Asian country. And so our national origin would reflect all of that diversity. And if somebody discriminates against one aspect of my national origin, then I can advance this type of claim. This, by the way, national origin has nothing to do with citizenship. I might be a U.S. citizen and still allege national origin discrimination. In addition, we have religious discrimination. I am entitled to not be discriminated against based upon my religion, whatever that might be, Christian, Jew, Hindu, Muslim, or even agnostic or atheist. And in fact, I might have a religious belief system that doesn't fit into any or into a more maybe formal or traditional category. Maybe it's my own religion that I've developed on my own. As long as I sincerely believe it, then it counts as my religion, or in case of atheism, my non-religion, and I am entitled to protection under that basis. Finally, we have protection from disability discrimination. Again, we talked a little bit about this in Chapter 1. What disability is protection is when a person has a mental or physical limitation that substantially limits a major life activity. Again, that's a technical definition, but it's the types of things that you'd ordinarily expect a disability to be: blindness, deafness, a learning difference, a mental health issue, things along those lines. All of these categories that we talked about can be expressed through some type of discrimination, but also through harassment. So I can be harassed because of my race, or because of my age, or because of my national origin, or my religion, or my disability. Now, we're all familiar with sexual harassment. That's probably a little bit more intuitive than these other categories, but we can also have other categories of harassment. Finally, we can have retaliation. A person can retaliate against us for having made a complaint. Let's say that I feel that I was subject to sex discrimination, and I complained to the EEOC about that. The EEOC might ultimately find that my complaint, though made in good faith, was without merit. But if the employer turns around and fires me because I made a complaint, the EEOC might find that my retaliation claim does have merit. So let's talk about these last two categories, because these last two categories have something different about them than the other categories. And they both have, it's because they both have the duty to reasonably accommodate. The employer has the duty to reasonably accommodate. So let's assume for a second that I am a member of a religion, and my Sabbath or my holy day, we'll say, starts at 7 a.m. every Tuesday morning, and it ends at 6:59 a.m. Wednesday morning. As a result of that, I am prohibited by my religion from working during that period of time. And you can see how an employer might say to me, well, we're fine with you having this religion, but you need to be here on Tuesday because we have a busy day planned. And I could say, well, no, I can't. And guess what? You have the duty to reasonably accommodate my religious views. And the employer, in fact, does. It's not good enough that the employer simply doesn't discriminate against me, that it doesn't treat me poorly because of my religion, but it has to assertively, reasonably accommodate my beliefs, assuming that they don't cause an undue hardship for the organization. The most common ways that we see religious accommodation is with respect to some type of Sabbath or religious day observance. Other ways that we see some accommodation would be a religious employee who does not feel comfortable doing a particular action. For example, let's say a religious nurse or doctor who is unable or unwilling to participate in euthanasia or abortion activities in a hospital. So sometimes the religious obligations this person has might interfere with their ability to do certain tasks. Finally, some people of certain religious beliefs feel that they need to express that through some way in which they dress, or they engage in personal grooming. For example, they may feel that they can't cut their hair, or they can't cut their beard, or they must wear either a certain type of garment, or a garment that is especially modest, or something along those lines. And so employers usually have to reasonably accommodate those unless there's a safety issue, something along those lines. The duty to reasonably accommodate disabilities is actually more onerous than the one to reasonably accommodate religions. So let's imagine that I am in a wheelchair and I am hired. And in my workplace, the tasks that I'm supposed to do is I've been hired as a file clerk. Well, I can access the bottom 3 drawers of the filing cabinets that I am supposed to work on. But the 2 higher shelves I am unable to access in my wheelchair. And so now the employer is going to have to figure out some way to accommodate me so that I can complete my task, my job tasks in those higher levels. Again, that the duty is for the employer to reasonably accommodate to the extent that it does not involve an undue hardship for the employer. We'll talk more about these protections when we get to Chapter 7 and 8. There are other governmental agencies. I'll just briefly touch on these. One is the EPA, the Environmental Protection Agency. This can be relevant when we're looking at waste discharge and pesticide usage, say at a hotel that obviously is concerned about having beautiful lawns. They might do laundry tasks there where there's a lot of wastewater to make sure is discharged appropriately. We also have the FDA, which is the Food and Drug Administration, and of course they're interested in food safety and appropriate labeling of foods, also using terms like low calorie and light when you're talking about certain food items. And although, so that might be important if you, for example, you're developing a menu at the restaurant and you use certain terms or make certain statements about the number of calories in a dish, what are the regulations about how you might be required to prove that information. Then we have the ATF, which is the Bureau of Alcohol, Tobacco, and Firearms and Explosives, and they are involved in the regulation of alcohol sales and how you go about doing those tasks if you happen to have a bar or a restaurant in which you serve alcoholic beverages. Here's another governmental agency, federal government agency to be aware of, and that is the Department of Labor. This is actually, maybe a little surprisingly, the EEOC that we talked about earlier is not part of the Department of Labor. So some of the organization of some of these governmental agencies don't always make the most intuitive sense. But the Department of Labor has several sub-agencies. One is the Wage and Hour Administration. One, again, most of these are under the Wage and Hour Administration. One of the tasks for the Wage and Hour Administration is to administer the Fair Labor Standards Act, which stands for FLSA. This is the statute that establishes the minimum wage, establishes that workers who are covered by this particular statute must be paid time and a half for hours they work over 40 in a given week. And finally, it regulates some aspects of child labor, in other words, labor by individuals who are under the age of 18. This also, the topic of child labor is also significantly regulated by state law. Then the DOL also regulates ERISA, which is a statute that has to do with pensions and welfare benefits, and the WARN Act. Let's assume for a second that you administer or manage a chain of restaurants, significantly sized restaurants with significant staffs, and for whatever reason one of the restaurant in the chain you've decided to close, maybe due to lack of profitability, for example. Well, you may be required to comply with the WARN Act and notify the employees on a certain schedule about the potential for this workplace to be closed. There's also a statute called the Employee Polygraph Protection Act. As you may be familiar, polygraph tests are tests that are designed to determine whether a person is being truthful. They're sometimes used by the police and by other law enforcement agencies in an effort to uncover facts that might lead to criminal prosecution. It's very, very difficult to use these in a legal way in the workplace. And so the strong advice I have for you is not to use any type of polygraph in the workplace. That's just not an effective way of managing it. The risks of doing it incorrectly and the fines that can follow from that are huge. And in fact, you shouldn't even rely upon the results that if the police conduct a polygraph, very, very regulated area. If the police choose to do a polygraph, let's say there's been a theft in your store, my advice to you would be to in no way assist the police in conducting the polygraph or encouraging employees to take the polygraph, and not putting any weight upon any results that the police have with respect to the polygraph. The reason that the Employee Polygraph Protection Act exists is basically polygraph tests are, for the most part, a silly kind of a Ouija board approach. They are not reliable at all to determine whether someone is truthful or not. And so why waste your time, and why go to the hassle and the potential liability to really not find out any useful information? Then we have the Family and Medical Leave Act, which is the FMLA. We'll touch briefly on this later on. The biggest thing to say about this law, though, is that it is an incredibly complicated statute with incredibly complicated regulations that are very, very difficult for an employer to comply with. The law grants employees, some employees, not all of them, some time off from work, either due to personal illness or because of the illness of a close family member. And there's other situations too that just kind of introduces you to the topic. One of the takeaways when you're dealing with the FMLA is not to trust your gut, because the FMLA works in a very different way than most other of these laws provide. So if you're kind of thinking, oh, surely this works like XYZ law, that's how I will assume it works, you're setting yourself up for heartbreak, because it's just not going to work that way. You have to be very familiar with the statute when you're coming up upon a compliance issue, and probably seek the assistance of at least an HR professional, and more likely an attorney, to make sure you're getting it right. The DOJ may be another agency that you work with, and they don't administer the employee aspects of the Americans with Disabilities Act, but they administrate the public accommodation parts, the customer-facing parts, the parts of the law that establishes how your hotel rooms have to be configured so that disabled guests can use the facility appropriately, or how your restaurant has to be configured so that disabled patrons can use the facility safely. The USCIS is an agency that it's actually kind of a group of agencies that within the federal government that handle immigration services and citizenship services. The biggest way that this impacts employers in the hospitality industry is that the employer has to confirm that the employee is eligible to work in the United States at the time that the employer is hiring the employee. A really important thing to do. Doing it correctly can be a little tricky sometimes, because the I-9 process is not an easy one. It's not a very straightforward one, but it is a necessary one, and doing it poorly can result in a significant amount of exposure to the employer. So when we consider immigration, we're really looking at two categories of non-citizens. I'm sorry, well, two categories of employees: the citizens and then the non-citizens. So citizens would be people who are a native born, in other words, people who were born in the United States, or who were perhaps born outside of the United States but have a U.S. citizen as a parent. And then those individuals who are naturalized. In other words, they had a different citizenship, but they chose at some point to become U.S. citizens, and now they are U.S. citizens. From a legal perspective, there really isn't a difference between a native-born and a naturalized citizen. I think probably the only difference is that who can become president, for example. So that's one category that we're looking at, citizens. Another category are aliens. And again, we're not talking about ET here. We're talking about human beings from planet Earth, but are people who are not citizens of the United States. And again, the people who fall into the alien category fit into two separate categories. And one are the immigrants. These are people who are aspiring to become citizens. This is a permanent deal on their part. They aren't going back. They may visit where they came from, but they are not planning on remaining citizens of where they came from. And then another category are non-citizens. These are people who are just planning to spend a while in our country, and they are planning at some point to leave. And so it's important, and we won't see in this particular course, but just know that these distinctions are legally significant in trying to sort out how a person's immigration status plays out and what types of documents are required. Two common types of visas that aliens get, aliens who are hoping to work in the United States get, are H-1B and H-2B. H-2Bs can be especially useful in the hospitality industry, especially in places in which there's a shortage of workers, and maybe the employer needs to increase its staff for a short period of time. Maybe there are housekeepers staff or there are groundskeeper staff, things along those lines. That would be an H-2B situation. So we've talked about federal regulatory agencies, but of course we also have it on the state level. We have an employment security agency. What that's called in Texas is a Texas Workforce Commission. You do need to know this information. You won't find it in the textbook, obviously, because our textbook is national, but that's the name for our particular agency. And it administers both unemployment benefits. It assists the hiring process in many cases. You don't have to be eligible for unemployment benefits, for example, to use the job placement services the Texas Workforce Commission provides, and they are intended to benefit not just the employee, but also the employer. Finally, the Texas Workforce Commission Civil Rights Division, or Commission, excuse me, investigates employment discrimination. It performs a similar function to what the EEOC does on the federal level. Then we have, as most states do, an Alcohol Beverage Commission, and this is called the Texas Alcohol and Beverage Commission. And again, it regulates the things that you would expect, the sales and importation and transportation of alcohol. Texas, as I'm sure you know, has kind of an unusual system for determining where alcohol or various types of alcohol can be purchased. So I have pulled up this website right here. I'm going to go ahead and click on this. This is the website that I had in there, and it shows you here are the list of counties that are completely wet as of November 2016, meaning that you can buy alcohol and beer and wine both in restaurants and in package stores. So we see here, for example, we have Bexar County, we have Comal County, Jim Hogg County, Hidalgo, Guadalupe County. As you can see, a total of 53 counties. We have over 250 counties overall in Texas. And we have 7 counties that are completely dry. And you can see just by the names, they probably aren't counties that ring a lot of bells for you. They're, I'm guessing, more rural counties. And you can see over here, we have, where is that? Here, wet dry spreadsheet as of May 2017. Well, I've already pulled that up and we can see here. Here is all of the Collin County rules. So you can see we have, gosh, probably 30 different, at least 25 different scenarios that play out just within one county. And you can see, let's look at Plano here. It's wine, B off, W off, DS off, RM. And you'd have to go and look at the terms here to interpret. For example, DS off means sale of distilled spirits for off-premises consumption authorized. W off is a sale of wine for off-premises consumption authorized. And you can see cities like Plano that are partially in Collin County and partially in another county, in this case Denton County. You'd have to go to the Denton County part. So let's just go down to Denton and look at that for a second. You can see most counties have a variety of, and you can see Dallas is going to have a lot too. So let's go down to Denton. And you can see here we have Plano, and here we have some more information about Collin County. So anyway, this can be a helpful way of having some familiarity about what the rules are in a particular county. Unemployment benefits. These obviously are benefits that an employee or former employee is entitled to when he or she loses a job without there being any just cause for the termination. The employee pays in um, uh, insurance. Insurance is provided for this purpose, and when the employee loses his or her job, basically you're filing an insurance claim. Just like, when your house has hail damage, because you have insurance, you're able to collect that amount of money. But not all unemployment claims are found to be meritorious. For example, if I resign my position, I am not eligible for unemployment benefits. Or if I engaged in misconduct related to work, for example, if I stole from my employer or did some other misdeeds, then I would be ineligible for unemployment benefits. So employers definitely get to challenge unemployment benefits eligibility. You may say, well, why should an employer challenge? Well, the same reason that you don't file on every single claim that comes along with respect to your house, because if you file too many claims, you're going to find your insurance rate goes up, right? And that same idea applies to employers. If an employer has a lot of unemployment benefit claims filed against it, it will find that its experience rate will go up significantly, and it will end up paying more every year for the unemployment coverage that it is required to have in that particular state. On the other hand, though, an ethical employer does not challenge meritorious unemployment claims. And so you need to make sure that you have a good basis for that. Here's a list of a variety of state agencies. Again, we have the Treasury, the Comptroller's Department that collects taxes, the Attorney General, and this is something that we'll talk about later on, but just so you'll know, Texas does not have a franchise registration law. We have a business opportunity law, which we'll talk about later on, and the Texas Attorney General is not involved in regulating franchises in the way that occurs in certain states. We don't have as much of a statewide public health department as some states do. Each county and municipality are involved in those functions. For example, well, we'll talk about that when we get to the local regulation. Then obviously we do have a Department of Transportation, but again, establishing speed limits within a community and setting up stop signs and yield signs and traffic lights and things like that are done on a local level. So they're not something that is necessarily centralized. I mean, obviously things with respect to, say, 75 and the Sam Rayburn and things like that, yes, those are more than just what one city decides to do, but how the city of Allen chooses to handle Stacy, for example, is Allen's choice. Then we have workers' compensation. Texas is very unusual in how it handles workers' compensation. I apologize for this slide. Apparently it didn't format exactly right. A workers' compensation protection is like an insurance program. It provides an employee with benefits if he or she is injured through the workplace. The government agency in Texas that administers that is the Division of Workers' Compensation, and it's part of a larger Texas agency called Texas Department of Insurance. Texas is, as far as I know, only one of 2 states in the United States that permits employers does not require employers to cover workers' compensation benefits for its employees. The other state is the state of Oklahoma. We call this in Texas going bare, in other words, choosing not to carry workers' compensation insurance. This was something that began in the early 1990s in Texas, I believe, and so we've had close to 15 to 20 years of experience without the requirement of workers' compensation coverage. A fairly significant percentage of Texas employers have chosen to go bare, and when an employer makes that choice, makes that election, there are certain posters that need to be posted, lots of different things that flow from that. Again, it's a very regulated topic. And let me just go back and talk about this. I meant to say this earlier. When we were talking about all these different statutes, all of these statutes, all of the Osha statutes, and the Civil Rights Act of 1964 statutes, all of those have particular posters that have to be posted in the workplace. I think I talked about it with respect to OSHA, but there's posters really with respect to all these statutes. And so you have to make sure that you're putting them up and putting them up in the right places with the right information on it. And one of those posters that you need to have in the state of Texas is a poster that explains whether your employer has chosen to gone bare with respect to workers' compensation coverage, or whether the employer has chosen to provide workers' compensation coverage to its employees. Dram Shop Acts. These are laws that are designed to impose liability on restaurants and bars when restaurants and bars overserve a customer who then leaves the store inebriated and is involved in an accident. And then the person who is injured sues most likely the person who caused the accident, but also the restaurant or the bar that served him. Anyway, we do have a Dram Shop Act in Texas. Let me show you that act. Here we go. And this is the act here. Providing, selling, or serving an alcoholic beverage may be made the basis of a statutory cause of action under this chapter, and may be made the basis of a revocation proceeding under Section 6.01b of this code upon proof that at the time the provision occurred, it was apparent to the provider that the individual being sold, served, or provided with an alcoholic beverage was obviously intoxicated to the extent he presented a clear danger to himself and others, and the intoxication of the recipient of the alcoholic beverage was a proximate cause of the damages suffered. In other words, because the person was drunk, that's why they got in the car accident. An adult 21 years of age or older is liable for damages proximately caused by the intoxication of a minor under the age of 18 if the adult is not the minor's parent, guardian, or spouse, or an adult in whose custody the minor has been committed by a court, and the adult knowingly served or provided to the minor any of the alcoholic beverages that contributed to the minor's intoxication, or allowed the minor to be served or provided any of the alcoholic beverages that contributed to the minor's intoxication on the premises owned or leased by an adult. This isn't the whole statute, but it gives you a flavor of what our Dram Shop Act provides, and it's a pretty standard Dram Shop Act. So now we're up to local regulations. And of course, we see lots of regulations in this area that affects the hospitality industry. One would be the inspection of restaurants. And I've listed the names of the agencies that we see in our 4 big cities. So we have Frisco Health and Food Safety, Plano Health Department, McKinney Code Department, and Allen Environmental Health Division. I've gone ahead and pulled up the Plano website. And so I'm just going to type in a restaurant name from Plano. Oops. And we can see what it scored. So this is Whiskey Cake off of the Dallas Parkway, and we can see its latest score was an A. It also has gotten as low as a C and as high as an A before. So that's an interesting account of that. You can type in the name of any restaurant. Some jurisdictions will give you letter grades, some will, here let's just click on this and see a little bit more detail. Here they list the problems that they found and specifically what the occurrences are. Let's go down to the C1. I guess there's going to be more problems with this one. And some of these are listed as non-critical and some are listed as critical. So again, this gives you an overview of what you might be concerned about. Might be especially important if you want to have confidence where you're going to eat before you go to eat there. Sometimes the nicest restaurants don't always have the best health record, so it's a good thing to be aware of. in that area. In addition, hospitality industry often is concerned about building codes and zoning rules. You want to be in the part of town that you want to be in, and if that area isn't zoned the way that you want to be in, you may want to seek a variance. And again, I've listed here the 4 agencies that we deal with in the bigger cities in Collin County. We have the Frisco Zoning and Planning Commission, the McKinney Zoning and Planning Commission, the Plano Planning and Zoning Commission, and the Allen Planning and Zoning Commission. So you can reverse those names again. I've gone into the McKinney one, and so this is the McKinney website for its zoning function. And then here is a list of some of the items that it's been considering recently. And you can see the various aspects. There's a Pamper Me Salon Spa, a specific use permit for personal service, and it gives us the location. It might be the one that's the best fit for. See if we can see any other names. Here's a Waddell Street Bed and Breakfast Inn. Again, we can see a specific use permit request for a bed and breakfast. Here we have Hank's Texas Grill, specific use permit request for a private club. We have the Celt Irish Pub, again, another specific request. Those might be the big ones. So anyway, that's another example of a function that you might be involved in when you are opening a new facility, such as a restaurant, a bar, or a hotel. Wage garnishment. Texas is generally speaking, a very pro-debtor jurisdiction, and so it's difficult to, in fact, I would say pretty close to impossible to garnish wages unless it has to do with some kind of federal claim or child support. So if it's federal taxes, federal student loans, alimony, or child support, those can be garnished, but for most other purposes, a Texan's wages cannot be taken from some other person through a garnishment situation. There can be cases where buildings have been designated as historical monuments, and sometimes those can be hotels or other places. And sometimes businesses choose to use those facilities because they're, have a lot of atmosphere, a lot of character. And yet using those facilities can present questions because your ability to change them, to adapt them, to modernize them, to add things like certain types of plumbing or certain types of air conditioning or things along those lines might become more expensive to make those types of changes. Fire departments, obviously, I have a little typo there, I apologize, establishes, here we go. Obviously, their main job is saving lives, but they're also involved in building inspections, and they can assist you in training your employees. Finally, fire departments establish the maximum occupancy for a particular space. We see this when we go into restaurants and bars. It tells us how many people can be in a particular space safely. When an emergency arises, a fire or some other incident, if there's too many people, there can be a crushing situation, dangers associated with that. And so keeping track of that occupancy number and making sure that your facility does not go over that number is an important function for that hospitality manager to be aware of. And obviously we have general law enforcement, police officers, and tax assessor collector functions. We've already talked about the idea of garnishment. Again, the technical definition for garnishment is a court-ordered method of debt collection in which a portion of the person's salary is paid to a creditor. And again, the employer is ordered to take the money out of the employee's wages to give it to this creditor. But as I say, there's relatively few times that we actually have that in Texas because of our pro-debtor culture. Here are a variety of travel and tourism industries or agencies that are federal government related. Obviously, many hospitality businesses are related to the travel and tourism business, and so these agencies can provide value to you as you grow your business and market your business. And again, there are international agencies. Obviously, many times hospitality businesses are international. So let's turn from talking about the various agencies that have some connection to our business to talking about how to manage conflicting regulations. For example, let's go back to our discussion of age discrimination. You may recall that I said under federal law, age discrimination protection begins on one's 40th birthday. When one is 39 years, 364 days old, one has no protections under federal law from age discrimination. That's how the federal law works. But in some states like Florida, you can be entitled to age discrimination protection when you're just 16 years old. So let's say that you are running a restaurant in Florida, and as somebody comes to your business, he's 25 years old. You have another candidate who is 55 years old for the same position. You interview both. You're thinking to yourself, well, I know under federal law and Florida law, I can't discriminate against the 55-year-old because he's over the age of 40. And I know under federal law, there's no limitations or protections for the 25-year-old based upon his age. But I do have this Florida state law. Does the Florida state law control in this situation and provide this potential employee protection? Or does the federal law, which doesn't give any protection to the 25-year-old, does it control? Well, the general rule is that businesses have to follow the most restrictive regulations. So in Florida, you have to not discriminate against people over the age of 40, and you also have to not discriminate against people under the age of 40. But again, if we go to Texas, where there is no under 40 protection, you just have to start worrying about that at age 40. So when regulations provide more protection, either the federal statute provides more protection or the state statute provides more protection, you want to make sure you're providing the most protection available under those circumstances. Now, it would be lovely if you could be certain that you're never going to violate any type of regulation. But honestly, despite your best efforts, human beings are human beings, and there's lots and lots of stuff out there to follow. And so it's pretty likely at some point you're going to be in violation of a regulation. And the most important things to keep in mind when you are trying to avoid that situation is, again, that STEM guidance. You need to make sure that you're selecting the best employees who care about legal compliance. You want to be sure that you are training your workers so that they know how to comply, that you're educating yourself so that you're in the best position to be successful, and that you're managing the workplace actively and responsibly, especially by motivating employees to put their best efforts forward. And that you're also thinking about ethics, because if you are behaving ethically, even when you don't necessarily know all the ins and outs of the law, you are definitely increasing your chances of being in compliance. So let's assume, though, that the government has raised a concern. The government is thinking perhaps you aren't complying with a particular regulation or rule. At least they're looking into the matter. Well, one of the key ideas you want to look at here is going to be documenting whatever happens with respect to this matter. So you're going to want to keep records, careful records of everything that you receive from the agency and everything that you send out. And you're also going to want to date them, because many times there's deadlines that flow from that. You might have 20 days from the date of receipt or something along those lines. You'll want to read everything very carefully to see what the allegations and concerns are, but you'll especially want to read them with respect to deadlines. And most of the times in these documents, or many times, they're not going to give you a date like June 17th, but they'll say 27 days from the date of receipt. So you have to sit down and do the math. Then you'll also want to look at what are the instructions. What do I need to do now in order to comply? Obviously, you want to assess the severity of the complaint. Sometimes that's hard to do if you're a layperson. You don't necessarily know what the fines are or how likely it is these fines will be charged against you. Depending, though, upon the seriousness of the matter, it certainly makes sense to consider consulting with an attorney. If you're in an organization that has attorneys in-house, you'll definitely want to bring this to the attention of that department. If you don't, very likely you'll want to bring it to the attention of somebody at a pretty high level within the organization. You won't want to wing this. You'll want to at least get your boss in the loop to make sure that you're handling it the way that's appropriate. And then, of course, you'll want to develop a plan. How are you going to approach this? And sometimes it will be with an attorney. Sometimes you may decide that it's not necessary that you have an attorney in this particular case. Even if you start without an attorney, it doesn't mean that you're committed to that course of action. It may appear to be a frivolous complaint at the beginning, but when you learn more about it, you may discover, oh, wait a second, there's a little bit more to this than I initially thought, and that might be appropriate in those circumstances to get representation at that point. We talked in Chapter 1 about how the law is constantly changing. The same is true for the regulatory landscape. In fact, I would say that's more quickly changing than statutes. It takes a pretty significant amount of effort to pass a statute and certainly to amend or revise a statute. Regulations are significantly easier to write, to rewrite, to change. And so we actually see more change in this area than we do with respect to statutes. Many larger corporations are going to have their own in-house counsel, which many times those departments will be very actively involved in training managers about what needs to happen, and maybe actively educating and presenting you data about the particular regulations, say, in your community even. If you are a franchise, your franchisor may provide many of those functions to you. If you don't have those types of assets available to you, you may want to look to various trade associations or even chambers of commerce that can provide you with information. Government websites can also be useful. And then we also have hospitalitylawyer.com. This is actually run by Stephen Barth, who is the author of our textbook. He's a respected attorney who practices in the hospitality area, and so this is a useful resource to be aware of. I hope this information has been helpful. As always, if you have questions, feel free to email me at cgroover.collin.edu. Again, please don't send your message through the Canvas messaging tool. I just don't check that, so you won't be receiving a response from me if you send it to me through that mechanism. Even better, consider stopping by my office hours so we can talk about whatever questions or concerns that you have and maybe do a bit deeper dive. I thank you for your attention. As always, we've got a discussion board and assignment posted in the module, so be sure to review those so that you can start on those assignments as well. Thanks for your attention and have a great day.